All right. Well, as it relates to mom's disposition, counselors, I'll let you address what was discussed at sidebar.
Thank you, Your Honor. There was just some concern about ensuring we're complying with the statute and no, I guess, issues moving forward for appellate purposes or otherwise. So at this point, we're going to, I believe we're all in agreement for an adjournment for the initial disposition until February 8th to permit the LJL to speak with the children. And that way she has a better idea of their needs, their desires, and we can ensure that that is adequately addressed at the dispositional hearing.
Ms. Berger?
Yes, Your Honor, I do believe that that accurately reflects our discussions in our sidebar. I do generally object to proceeding when that standard has not been met. So I am in agreement with continuing to the 8th.
Very good. I think you also expressed some concern that your client maybe needed a little more time with the court report.
Yes, I've been able to speak with her a little bit more since our last hearing, and we are requesting additional time with the caseworkers to review that. It has been disclosed that she does have a learning disability, so I think that in order to comply with all regulations, we need to make sure that she does fully understand that.
So would you be able to meet with her, Ms. Madrid, between now and when we come back to go over that?
Yes, we actually have a TAM scheduled in 2 weeks, so.
Okay, so what's being asked of us, Ms. Chanel Deakins, is to move today's hearing to February 8th so that Ms. Heiss can talk with the children and you can have a little more time with the court report.
It's just, right.
Okay, I think those are good reasons to allow for the adjournment. If there's anything else that needs to be addressed in the interim, please make sure you bring it up with your attorney and with Ms. Madrid. Family team meeting is a great place to do that.
Why my attorney is right here, because I did bring this up with her prior. My parenting time. How is that supposed to be?
So, Ms. Berger, do you want to elicit testimony from your client on this point or address this at all between now and when we come back? Leave it at an FDM? How do you want to tackle it?
I probably will, if we're going to continue with dad's portion, I probably will just ask the caseworker to explain it.
All right. Why don't we tackle that now, actually? So Deputy Ames, would you swear in Ms. Madrid for us?
You want
Can
to
I stay there? What?
I think it should be brief. Go ahead.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, Ms. Madrid, what's going on with parenting time?
So Ms. Deakins is visiting Mondays, Wednesdays, Thursdays, and Saturdays. Right now we have a draft time frame of 6:15 to 8:15, which is her availability after work. But she's able to stay there longer, or she's able to add in times as long as it's agreeable with the caregiver. So she's able to come and visit during those days, stay longer, do bedtime. So she does have liberal parenting time as long as it's agreeable with the caregiver.
Okay. Questions, Ms. Berger?
Thank you. Ms. Madrid, can you explain a little bit more why maternal grandmother is no longer an approved supervisor?
Yes, so it's my understanding that at the time of placement, there was some kind of situation that occurred where she was not appropriate in front of the children. And so during a transfer meeting with CPS and foster care, it was agreed that as of right now, she would not be appropriate due to concerns of behavior that she had in front of the children during placement, as well as concerns of her not being able to intervene if mom is inappropriate or having inappropriate behaviors around the kids.
And were any of the things that were said by grandmother, were those said in front of the children?
It is my understanding that they were present, yes.
Okay. And is parenting time at the agency at all, or is it all at placement's home?
So for 3 out of the 4 days, it is at the caregiver's home, and then one of the days it's at the agency so that we can have an opportunity to view their interactions and report on that to the court.
And who's supervising those at the agency?
That is between me and the visit staff at the agency.
And are those visits not able to be supervised or observed at the relative placement home?
I can explore that if the relative is in agreement with allowing that, yes.
Okay, and they don't have to be in agreement for parenting time. Are you aware of that?
If it's in their home, it's my
Correct.
understanding that yes.
The judge can order that, is that correct?
It's my understanding that if it's in their home, they have to agree to it.
Okay. I have another question, Judge, thank you.
Ms. Heiss?
I have no questions, thank you.
Very good. Does that answer your question? Or do you, I mean, you might need to take some time to talk to Ms. Berger about this privately, it sounds like. Ms. Berger, did you have anyone else you wanted us to hear from, or any other argument that you wanted to make on the issue of parenting time pending the resumption of our proceedings?
I'm just gonna get it, because it's hard for, I love the other kids that are at the placement home. I love them. They're my nieces. It's just when I'm trying to spend time with my kids, it's hard to. So I like the opportunity that if my mom could be reestablished as a supervisor, for her and I to be able to pick my kids up, go to my grandmother's house and have my visits.
Well, at this point in time,
Or
that's not something that's approved by the department, so that would be something you'd have to work with them about and work with Ms. Heiss about. I mean, if there's not an incident, then you're gonna have to work through that, and the family team meeting is probably the best place to do that, honestly. So I would recommend that you contact Ms. Berger after today's hearing to talk through that strategy. All right, I'm not gonna make any changes to parenting time at this point. It sounds like it can't, there is some tweaking that could be done to potentially make it more optimal, but it certainly is satisfactory at this point. Although I do encourage Ms. Madrid, and she knows that I always encourage additional parenting time as much as possible. So I can trust her to continue to work on that. And Ms. Berger is an excellent advocate. She'll be definitely working to increase that as much as we can safely, as will Ms. Heiss. So for now, all prior orders will remain in full force and effect, and we'll take your case back up on February 8th at 10. So you're welcome to stay if you wish, or take off for today. I'll have the order of adjournment for you in just a moment.
Paper find Mr. Deacons.
Yes,
Okay.
yep, we're gonna tackle his in just a minute.
Okay, thank you.
We are gonna be ready to go back to Mr. Deacons. Are we still on record? Nope. How was it? Well, okay, you're right.
We're back in the manner of its children, file 14068.
All right, we are back as it relates to the adjudication trial that began earlier this morning for Mr. Deacons. I have the names of our participants, please.
Lee Heiss, lawyer guardian ad litem.
Ms. Tasha Thomas, counsel for the department.
Chelsea Grant with the department.
All right, Mr. Brooks, can you hear us okay? Oh, did we lose him? I know we have Mr. Deacons. Mr. Deacons, would you give us your name, please?
Aaron Deacons, father of the kids.
Thank you, welcome back. Mr. Brooks, can you hear us now? Well, Well, we might have to take a little break to give a call over to his office and make sure he knows we're ready for him. Last call for Mr. Brooks. All right, we'll take a brief recess and I'll ask my.
You
oh,
can't,
there he
you
is.
can't hear me?
Now I can.
Yeah, I've been here for 30 minutes.
Well, thank you for confirming.
Mhm.
All right, we are ready to go back on for your client's adjudication trial to finish it up. Ms. Thomas.
Thank you, Your Honor. When we had recess, I asked for the recess in the event Ms. Deacons would testify. At this point, I am not going to call Ms. Deacons and in closing my portion of the arguments or presentation.
All right, did you wish to have any witness testimony, Mr. Brooks?
No, we already did it.
Ms. Heiss.
I have no witnesses today. Thank you.
All right, closing arguments then.
Thank you, Your Honor. As this court is aware, the standard that the department must meet is a preponderance of the evidence, meaning more likely true than not, that at least one of the allegations in the petition are true and sufficient to find that there has been a violation of the juvenile code. And as it relates to Mr. Deacons, we are specifically asking that the court find that he was able to provide care necessary for the children's health or moral well-being and had refused to do so, and that his home environment is an unfit place for the children to live because of cruelty or depravity on part of the parent. In this case, you're not asked to look at the legality of the actions, but whether those actions pose a risk of harm to the children. As this court's aware, these proceedings are not meant to be punitive to parents, but to focus on the children's well-being. In Mr. Deacon's own testimony, there is a pattern of domestic violence, meaning violence amongst members of the home, not just intimate partner violence. And this remains unremedied, as it was the reason the children were removed from his care dating back to 10 or 11 years ago. And despite completing the prior services to remedy those concerns, he has failed to demonstrate the long-term benefit from those services. His position is that it's not illegal to use corporal punishment. This is despite the fact that he also admitted his anger is sometimes too much and gets in the way, that he has mental illnesses to the extent that it impairs his ability to maintain employment and to respond appropriately at times, especially without medication, and that he struggles to manage his anger. And this is from someone who has access to resources, is engaged in those resources, but is struggling to demonstrate the benefit. Ms. Grant worked with this family for a month and a half before coming to the conclusion that the home was not safe for the children to remain in. Whether police are called arbitrarily or rightfully, this demonstrates the dysfunction in the home. Perhaps the children have not needed medical treatment for any physical ailments as a result of abuse, but their actions in seeking help speak for itself. Mr. Deacons may believe that the allegations in the petition are exaggerated, yet he admitted to a majority of them during his testimony, specifically hitting, slapping his children, having a quote unquote tough relationship with his wife, and arguing in front of the children, not taking his mental health condition seriously enough to maintain medication, his medication regimen. And while none of these things always necessitate court intervention, Ms. Grant testified to all the efforts put forth to help this family address those concerns. And simply put, they weren't enough. Mr. Deacons couldn't comply with court directives to not have contact with his wife or go to the family home. And at some point, we'd hope that either Mr. Deacons or Ms. Deacons would have the wherewithal to stop the cycle. Ms. Deacons has already taken a plea, and Mr. Deacons is equally part of the conditions that put these children at risk for more emotional and physical harm. And we believe, based on the testimony we've heard today, that our burden has been met, and we ask this court to take jurisdiction over Mr. Deacons. Thank you.
Thank you. Mr. Brooks.
Listening to counsel, I wonder whether or not we heard the same case or not. Now, I'm 76 years old. I was raised and educated under an entirely different set of cultural norms as regards corporal punishment than Ms. Grant, who was the DHHS witness. We're simply going to have to agree to disagree. But there's one thing she and I cannot disagree on. There is no medical evidence of physical abuse. There are no reports from the schools about physical abuse to the department. There are no police reports confirming physical abuse of these children. In short, all of the claims of physical abuse are unsubstantiated or rely upon the testimony of my client's wife. And the most I can say about her testimony is that it's suspect and that she calls the police. Apparently, it's a coping mechanism she uses, call the cops. At the best, you could call her testimony suspect, and at worst, it's exaggerated. Mr. Deakins, contrary to what the witness for DHHS said, is not in jail for domestic violence. He is in jail for violation of his bond conditions to keep him out of his house, a house that his wife kept calling him up or contacting him in some way to come back home. In short, the standard of proof, which is preponderance of the evidence, has not been met here. They don't like my client's way of punishing his children, which is not injurious to them in any way. Authorities have been brought in repeatedly and found nothing. And yet here he is having his kids taken away from him. I hope we don't have that kind of authority in the state government, because if we do, I definitely don't approve of it. Thank you.
Ms. Weiss?
Thank you, Your Honor. I hope that we're not perpetuating myths that domestic violence is only a physical act, and that children who are in the presence of parents who are yelling and screaming are affected negatively. We know that the contemporary science with which the social worker has been trained more recent shows us that children's cortisol levels are increased and they sustain high levels of stress hormones. And this is actually when there is stress in the home, when there's yelling and screaming and people hitting each other, not that the children are being physically hit. This is domestic violence in the presence of the children. We can measure the damage to developing brains so that we know that the children who are exposed to domestic violence develop triggers, and those triggers can not be commonly understood by caregivers, educators, and others in the community, so that their reaction, their behavior, their conditioning is treated as misbehavior. So we know that we have outcomes for these children who have had an incarcerated parent, had a parents with domestic violence, had a removal from the family. We know that their outcomes are measurably less successful than their counterparts who don't have these risks. I would ask you to consider that the domestic violence in the presence of the children. Now, these children are 14, 13, and 6. They are of sufficient age to articulate to us that they need help. And that's what they're articulating. They're articulating that the environment that the children live in is an unfit place for them to develop appropriately. So I would ask you to consider that based on the testimony that we heard today, there is domestic violence that is creating a risk to these children, both physical to them, but in addition to physical abuse to them, and separate and distinct, the domestic violence in their presence, in their family is damaging to their development. And I'd ask you to find for adjudication of this parent. Thank you.
Thank you. The court finds all interested parties were given notice for purposes of today's adjudication trial. I did have the benefit of reviewing the petition as Ms. Thomas took the testimony of Mr. Aaron Deakins, there are pending domestic violence charges according to his testimony, and I do think that there's probable cause that there's domestic violence in this home, that it's happening around the children. The children made statements to that effect to our investigating caseworker who testified to those, and those were uncontested. There is a history of involvement with CPS for the same reason, with services, and Mr. Deacon's testimony that he completed those services, but doesn't really know why he chose not to use those tools, further confirms that the dynamics that are currently in the home continue to reflect an environment of domestic violence, which is a danger to the mental health and the physical health of these children, as they would be witnesses to domestic violence between their parents. And I do think there's probable cause also to believe that Mr. Deakins is using physical discipline in a way that would constitute abuse, or at least to the frequency, to the extent that it may not be leaving marks, but it's certainly leaving marks on the mental and emotional health of the children as they reported. There's one of the children that was actively suicidal at one point, which is one of the risks that Ms. Heiss articulated. That is the effect that an environment like this has on the children. The domestic violence dynamics in the home by Mr. Deakins against his wife also is contributed to by the failure of Mr. Deakins to take care of his mental health. He has some pretty significant diagnoses that I understand as including schizophrenia, ODD, and was not taking his medications from October forward, which I'm sure frankly contributed to the decision-making that landed him in jail and charged with domestic violence at this time. He did share with us that at times he sees things that aren't there, and that his mental health does affect him, and that now since he has went back on his medications that he is improving. So that is optimistic. He is currently in jail because he failed to file court orders to abide by a no contact. And so it is appropriate to continue the removal of the children from the home where he has been shown to frequent despite court orders. I don't care, frankly, if it's because he thinks his wife called and wanted him back or not. There's a court order that prohibits him from being in the home. And furthermore, the court finds that he is a substantial risk of harm to the mental and emotional health of his children as a result of the mental health concerns and the domestic violence, which does constitute criminality. And for those reasons, the children must remain in placement. By extension, that the initial findings as it relates to the mother also remain in full force of effect as it relates to the placement of these children pending further proceedings. But I do think that jurisdiction is appropriate under the section of the law that Ms. Thomas asked the court to consider today, which is that environment which is characterized by domestic violence does and criminality does contribute to a significant substantial risk of harm, and therefore is a violation of the statute by the probable cause standard, and the court will take jurisdiction over Mr. Deakins for those reasons, with the idea that a case services plan will be put into place to further aid him in looking for housing, stable housing, and employment, which are also risks that we don't want to put the children at risk of restoring children to him with untreated mental health, pending domestic violence charges, patterns of domestic violence in the home, no home, stable home at this moment, and no employment in order to be able to make sure that he meets their needs. At the current moment, we find him contributing from the Illinois County Jail. So he is not able to take placement of the children at this time and is in need of case services in order to hopefully alleviate the risk of harm to his children. And the court looks forward to him making some progress on those points so that he can have some visitation and some time with his children safely. Our next stage of things will be, of course, the initial disposition in this file. We have some time the week of the 12th for that, and I'd like to invite the attorneys to look at their calendars. Let me know if they are available. 9:30 Tuesday, February 13th.
I am, Your Honor.
Yes.
Mr. Brooks?
It's fine, Your Honor.
All right, thank you. So we'll see everyone then on February 13th at 9:30 for the initial disposition. We'll trust the department and the foster care caseworker to reach out and work with Mr. Deacons as best they can to look at the case services that best reflect the issues that were identified by the court today. And unless there's any questions, that's all for today.
Your Honor,
Thank you, Your Honor.
This is just a matter of housekeeping. In findings, the, Your Honor had indicated probable cause standard, and I just want to ensure that the findings also meet the preponderance.
Oh, yes, sorry, yes, there is a preponderance of the evidence standard here as well, which is slightly higher, of course, than our probable cause standard, or than, I'm sorry, than the previously indicated standard, but I do find in the court order will reflect that it has met that standard.
Thank you, Your Honor.
Anything else?
No.
Okay. Thank you, ladies and gentlemen. That's all for today.